on the 29th of March. He allowed Mr. Querino's appeal against the Council's review decision dated the 24th of November 2022. And that decision was that 61 Hartree Lane in Cambridge was suitable accommodation provided in discharge of the duty that was owed to Mr. Querino under Section 193, subsection 2 of the Housing Act 1996. The review decision can be found in the core bundle at page...
Well, if you're going to take us to it for substantive reasons, of course, do. But I don't think we need a lengthy introduction to where everything is. We've got everything. We've read everything. So as soon as you feel able to, you can come to the issues.
Indeed. My Lord, before I'm grateful for the push along. My Lord,
nudge rather than push.
My Lord, I do want to take your lordships to some of the documents because that would be relevant before we look at the review decision itself. And the review decision sets out the facts which we can take by overview. My Lords can see page 56 in the core bundle.
It's just, sorry, one thing you haven't done, which I get used to all advocates doing, often unnecessarily, but on this particular occasion it might be necessary, is to remind us what papers we have. There is an oddity here because we have two core bundles.
There should only be one core bundle.
Well, I assumed that the second one we got was replacing the first.
Yes.
But in fact, it doesn't contain some of the documents it's supposed to contain. In particular, it doesn't contain the Respondent's Notice.
My Lord.
Now, I'm sure we're going to cope, but I'm just warning you of this because you may start taking us to page references and so on, find they're not there. The only actual thing I've noticed is the Respondent's Notice, but where there's one mistake, there might well be more. Because I started working on the old core, so be warned.
I'm grateful for that. My core bundle has the Respondent's Notice in it.
Where does it have it?
It's on page 18, my Lord.
Well, I have what I thought was the more recent core bundle, and the index, tab 2, says Appellants Replacement Skeleton.
Yes. Page
18. That's not the Respondent's Notice.
No.
And indeed, that's not just the index. The bundle is not. The document isn't there either.
My Lord.
So there has obviously been some confusion.
There has.
And we will cope, but don't just assume that if you give a reference, we will have what we're supposed to have.
My Lord, the core bundle, which I trust, whichever core bundle my Lords have been working from.
But I've transferred now to the new one, but I was then surprised to find it didn't have the right things in it.
It did. My Lord, for the review decision, my reference is the core bundle at page 56. If my Lord has a different bundle, I don't have the second bundle with me. I've just assumed.
Well, in my case, the review decision at 75.
My Lord, I'll take a note of that, and I will.
Well, okay, I thought this was just going to be easily coped with, but can we just work out what has happened here? We have a core bundle date stamped as being received here on the 7th of March with 18 tabs.
Yes.
And 150 odd, maybe 149 pages. Yes. Is that what council have?
No, my Lord, no. They're difficult. What happened? The confusion arose is my instructing solicitor proceeded to lodge this as that bundle as the core bundle without it being approved, and then the
approved by whom?
Approved by the respondent, and what then led was there to be a further agreement, a further index agreed together with a supplemental bundle, which most documents went into a supplemental bundle, and therefore you should have had a core bundle that ran to page 50, page 75, and then a supplementary bundle that ran from. That was a larger.
Well, I have got that. Well, but I thought that was one I had first. Maybe something funny happened in the office, and we got the. I don't. Does it boil down to this that you would? I haven't even consulted with my colleagues. They may have done the right thing, but I have the 75-page bundle, which I believed was the superseded one. But if that's the correct one.
That's the correct one, I understand. Yes, that's the correct one.
The internet, that's my fault. But,
I see.
But I've got the one with the Respondent's Notice in it.
Well, maybe I'm uniquely. I'd rather assume my.
Like my lord, I'd assumed that this fatter one was going to turn out to be the key one.
Yes.
But I had previously worked from the thinner one, and I'm quite happy to return to working with the thinner one.
I think the solicitors aren't here to look red in the face, but will you? Maybe they're watching, but could you just communicate that this sort of thing isn't helpful?
My lord.
And if there's going to be two bundles knocking about, we need to be told absolutely authoritatively which is the right one. I can't do what my lord has done because I've written all over these. So don't worry, I will find them. You give the references that you're used to, and that'll just take me a minute or two to catch up. Okay.
Can I apologise for the mix-up there is in respect to the bundles, and I will pass on the red face to those who.
Okay, well, let's get started. I've got that off my chest.
The review decision, my lord, in the core bundle, page 56, my lord's 75 starts. It gives the relevant facts in terms of the background to the offer of number 61, and that is that there was a Mr. Querino approached the authority as a person who had lost accommodation, having been evicted from his what was a temporary accommodation, flat 125 Newmarket Road, having been excluded from the matrimonial home by virtue of a non-molestation order. On the 10th of May 2022, he was placed in interim accommodation by.
Why are you reading us all this?
My lord, just giving you the facts.
Well, the point of my nudge was to tell you that we knew the facts.
Indeed, my lord. The temporary accommodation, my lord, that was provided ultimately at 116A Chesterton Road, the licence that to occupy can be found in the supplemental bundle at page 175. And this is accommodation provided by the council from its own temporary housing stock, and it's an excluded licence provided in discharge of the duty under 188 pending determination of the application.
We've only got, and this is a point Mr. Van Heegen made, we've only got one page of it.
There was only one page in front of the reviewing officer, but
has it not been possible to find the whole thing?
My lord, no.
Has anyone looked for it?
Yeah, it's not on the file, but one has to be limited to the documents that was in front of the reviewing officer at the time.
Anyway, this is what was before the reviewing officer.
Yes, my lord.
Okay.
The licence, the council then made a decision to accept the main housing duty on the 22nd of July in 2022, and then they made an offer of accommodation, which my lords will find in the supplemental bundle at page 197. This is the letter dated the 2nd of September. It's offered as a Part 6 final offer, which I'll come to in due course in terms of the definition. And it was offered by the council from its own housing stock, a social tenancy being granted for what is a one-bedroom flat on the 3rd floor, and the officer making the offer does deal with location of the property and access to doctors and services, access to hospital and so on, and then a paragraph, page 198 on the 4th paragraph, acknowledges that there was a desire that there should be more bedrooms to accommodate the children, but under the policy, council's policies, lettings policy, the officer was satisfied only a one-bedroom property was suitable for the needs, and that the children had were safe and able to reside at what was the former matrimonial home with their mother, and that they, as the council concluded, that they were satisfied that the children were safe at 53 Whitwell Way and that residents wouldn't impact their educational well-being, and concludes that the offer is suitable for Mr. Querino's needs and requirements, and then notifying him of the right to request the review of that suitability of that accommodation.
Not that it really matters, Mr. Trelville, but no need to read out addresses.
I apologise, Mark, yes.
Yeah.
So having been notified of the offer, Mr. Querino requested a review of its suitability on the 2nd of September, or sorry, the 8th of September, at page 200 of the supplemental bundle. And on the 12th of September, he accepted the offer of the accommodation, but under Section 202, he's entitled to continue with the requested review of the suitability of the accommodation, even though he has accepted the offer. So he accepts the offer on the 12th of September, and then we have the detailed representations for review made by on his behalf at page 202. My Lord will see those in the supplemental bundle. My Lords will see that in the letter through to page 206, and attached to that is the CAFCAS report.
Yeah.
That led to the council seeking to making inquiries with the author of the report, Ms. Jackson. My Lords will see that at page 225, 226 of the supplemental bundle. And then her reply, which we can find at page 227.
Yeah.
And that's the 10th of, the 18th of October, even though it's not dated, it's the 18th of October, that reply. My Lords will see at page 227 how she responds. My Lord may have seen this. Indeed,
We have seen all of this, Mr. Trelville. So, yeah.
And as a result of that reply, my Lord, the review decision was that the next step was the making of the review decision. The review decision, my Lords, as I'm going back to the core bundle, identifies the submissions at page 58, so it would be 77 for my Lord. The submissions that were made on behalf of Mr. Querino and the reliance on the CAFCAS report, and then at the bottom of the next page 60,
Which page?
It's my page 60 of
Luckily I haven't had both pages here.
My Lord.
But 60, or maybe not. My page, if I'm using what I thought was the same thing as you, that's halfway through the recitation of the solicitor's submissions.
And at the very bottom, my Lord, should see considerations. And then
no, sorry, that's page 61. Okay, I've got that now.
That's come as that. So I apologize. Yep. So under the heading, important note regarding evidence submitted, and then my Lord will have read that the conclusion was that the report can't be relied upon, will not be considered, and the decision maker will progress with the review disregarding submissions made specific to the report, and neither will I put forward any information specific to the report in my consideration. So
yes,
the approach taken by the officer was, in my submission, the correct approach. Namely, at that point there was no permission to adduce that report or indeed to rely upon it, and the officer then proceeds to consider the issue, which the principal issue, namely the question of whether or not the accommodation was suitable by reason of the fact that there wasn't an extra room for the children to reside there, albeit stay overnight or for a day or two, pursuant to any arrangement that was made between the relevant parties. The The officer addresses the question of the policy and identifies the relevant policy, my lords, as was identified in the offer letter. The relevant paragraphs being 5.51 and 5.5.2, and then in the subsequent pages of the letter deals with the question of residence of the child reasonable to expect to reside within the accommodation, etc. My lords have seen that. The appeal was allowed by the judge on three grounds. First was that there was a failure by the council to comply with Regulation 7.2 of the 2018 regulations. And secondly, the council failed to comply with Section 193F and subsection 8 of the Act. It hadn't identified whether or not Mr. Querino was able to extract himself from his existing obligations in the temporary accommodation before being required to take up the offer. And then finally, the council had failed to take into account the report, and therefore that as a report should have been taken into account, and that was decision was accordingly unlawful. In respect of the first issue and the failure to comply with Regulation 7.2, my lords will find Regulation 7.2 in the authorities bundle.
Yes, thank you.
And that will be at page 113, bottom right hand corner. And that provides that the reviewer, if the reviewer considers that there is a deficiency or irregularity in the original decision or in the manner in which it was made, but is nonetheless minded to make a decision against the interests of the applicant on one or more issues, the reviewer must serve a minded to find notification and then give an opportunity to make further representations, whether orally or in writing. So the duty is engaged where there's a deficiency or irregularity in the original decision or in the manner in which it's made. And for the purposes of this appeal, it is the first limb, namely whether or not there's a deficiency or irregularity in the original decision. For the purposes of applying this regulation, the first step is to identify what is the original decision. In this case, this was a review on the suitability of the offer, and that is the offer. So the original decision is the offer itself, which was made.
Oh, I thought. Yes, I see. Why did you say that followed from the fact that it was about suitability? I mean, isn't?
Well, because the offer was made, and the offer concludes this is a suitable offer. There is the right to request under Section 202(1). I'll take my lords to it if it need be. There's a right to request a review of the suitability of an offer, which is what in fact actually happened. And then the authority then have to undertake a review, and then under Section 203(4).
Yes, no, I understand all that. I obviously misunderstood the way you were going, but surely the original decision is the offer, full stop.
It is the offer.
Yeah, okay. Thanks.
But the offer is that it's an offer of suitable accommodation.
Well,
so that's what
it's an offer of accommodation, and a review is being sought on the basis that it is said not to be suitable.
Indeed.
Yeah.
Sorry, my lord, if I'm putting it a different way.
No. I'm sure it's my fault, but I thought you were making a more complicated point than you obviously were.
More complicated
thank
than
you.
it needs to be. My lord, it is what I would class and people would normally determine to be a suitability review. It's reviewing the suitability of the offer that is made in discharge of the
Essentially, as opposed to what other kind of review?
a discharge decision. So once an offer has been made, it can be accepted or rejected. The council then make a decision on whether or not the duty is discharged, and that is a decision as to what duty, if any, is owed. And if it is a suitable offer, then the duty is then discharged, and there will be a right to request a review of that decision. Now, the suitability. So for the purposes of this review, the issue was whether or not the accommodation was suitable. So the original decision must be the offer letter. And there's no dispute on that. That is the original decision for the purposes of Regulation 7.2. And my lord will see that from the offer letter that the conclusion is that that this is a Part 6 offer, which is a suitable accommodation in the view of the authority who made the offer, and it would be reasonable for Mr. Querino to accept it. The question then is, when we're assessing whether or not there's a deficiency or irregularity in the original decision, one has to look at the original decision and identify whether or not there is a deficiency or irregularity in it. And following the court decision in this court's decision in Akhtar and Birmingham, which my lords will find in the authorities bundle at tab 11, page 213. The courts held that there was no requirement for an authority to give a reasoned decision when making an offer. What happened in this case, my lords, is that the council, Birmingham City Council, had made an offer of accommodation, which the applicant rejected and requested a review of the decision, and on review the council upheld the review and concluded that the accommodation that had been offered was unsuitable. So then they made a second offer, and again the applicant rejected that offer, and but the council upheld the offer on review and concluded that it was suitable accommodation. And the appeal was challenged the failure to provide reasons, namely that had the applicant known the reasons why the council had accepted that the first property was unsuitable, she would have been able to make a decision, an informed choice, as opposed to just rejecting or accepting rejecting the second offer. I take my lords to page 223, paragraph 45 of the judgment of Lord Justice Atherton, and in particular page 40, paragraph 46, the rejection of the argument that as a matter of principle every offer letter should give reasons explaining why the offered property is considered to be suitable and reasonable for the applicant to accept. It is obviously implicit in every offer that the housing authority consider the property to be suitable in all material respects, including location, size and configurations. I cannot see any purpose would be served by a bold statement to that effect. So there is no requirement, and indeed there is no statutory requirement, to give reasons for making an offer and why the accommodation is considered to be suitable for the purposes of discharge. In contrast, there are requirements to give reasons which are adverse, whether a decision is adverse to an applicant. So, for example, if the decision is that there is no longer a duty owed, and therefore the duty has come to an end, the main housing duty has been brought to an end, that is required, the reasons are required to be given for that adverse decision, just as there is a requirement to give reasons for an adverse review decision. But Parliament has made it clear that as my submission has limited the requirement to give reasons to where there is an adverse decision. So the offer of the accommodation is not an adverse decision, and there is no requirement to give reasons. So it follows on, therefore, that the offer letter, which is the subject.
Well, it's an adverse, it could be said to be adverse in this sense that the applicant might, in a particular case, and had, I think, in this case, made it clear that he wanted a 2-bedroom property, and they've offered a 1-bedroom property. You can say, well, that's not adverse because they've made an offer which they believe is suitable. But on the only issue between them, it is adverse because they've taken a less generous view of what suitability requires. So is that, why isn't that an adverse decision?
Because, my lords, the requirement to give reasons is specified and linked to adverse decisions. For example,
I see that, but I'm saying this is an adverse decision.
But, my lord, there is no requirement in the statutory scheme that requires reasons to be given for why the authority consider accommodation to be suitable. So there is no requirement, in a sense, the suitability decision is not one that has to be reasoned, and is not what.
Right,
So
and you say you get that out of ACTA.
I get that out of ACTA.
Yeah, okay, fine.
And if there is, so when one goes to the Regulation 7.2 and the assessment of whether or not accommodation, whether or not the original decision is deficient or irregular, then in the absence of a requirement to give reasons, an offer, this is what this is the accommodation is offered, which we consider to be suitable, which doesn't have to be reasoned. There can be no deficiency or irregularity within that decision.
Why does that follow? I mean, I follow that if you simply had a one-line thing saying this is suitable, you would say, well, there was no obligation to go any further, and it's then going to be difficult to apply Regulation 7.2. But whereas here, more is said, why can't you look into the more?
Well, the question I suppose my lord's asking is why, if a local authority open the door and give reasons for suitability, does that therein engage Regulation 7.2? My submission, no, it doesn't, because there is no, the starting point is Regulation 7.2 cannot be engaged because the offer letter is not required to be reasoned and there doesn't need to be a requirement to specify why the authority consider it to be suitable. So it cannot follow in my submission that where an authority then go on and say, well, actually, we think it's suitable because it's close to the services and the shops and access to the amenities, etc. And that overview would trigger Regulation 7.2, so that it would then mean that there have to be a minded to fine notification.
I'm not sure I follow why not, because Regulation 7.2 says if there seems to be a deficiency in the original decision, then you have to send the minded to letter. But the original decision is what you see in the offer letter. If there is, hypothetically, some obvious flaw in the reasons given in the offer letter, why can't you detect a deficiency in the decision?
My lord, my starting point is that for local authorities generally, where they make an offer, given that there is no requirement to give reasons, a local authority that makes a one-line offer, we hereby offer you X, and we consider it to be suitable, that offer would not engage Regulation 7.2 because there's no requirement. My lord, coming on to but where the authority go on and then make a sorry, my lord, can I come before I go on to the next point that my lord wants me to address? If this court were to find that Regulation 7.2 is engaged, where there is no requirement to give reasons, and a bold statement of this accommodation is suitable and reasonable for you to accept, engages Regulation 7.2, then Regulation 7.2 will have to apply across the board to every offer of accommodation, because it would require the offer, and it would require local authorities to either set out in their original decision the reasons for their decision, to then against which then Regulation 7.2 is measured, or it's measured against Regulation 7.2 for the purpose of determining whether or not fine notification needs to be sent. But it would, if it was just a bold assertion or offer of this is accommodation which is reasonable, suitable and reasonable to accept, then Regulation 7.2 would always apply. In my submission, that's not what Parliament, nor indeed the Secretary of State, when introducing the regulations, envisaged. It was never envisaged that Regulation 7.2 would apply to suitability offers, suitability reviews of offered accommodation.
Why do you say that?
Because there's no requirement for there to be reasons given. Because it's only in the reasons that you can then measure whether there's a deficiency or irregularity in the original decision compared to the facts before the reviewing officer at the date of the review.
So each time it comes back to ACTA.
Yes.
But I thought the authorities told us that one could demonstrate a deficiency by reference to material that only comes into existence or becomes available after the decision.
My lord, yes. But Lord Justice Lewison in NJ makes that point, and it's quoted in Mohammed by Mr. Justice Prideman. And that's right. It does. There can, but in those instances that are referred to, they are dealing with discharge decisions which are reasoned. So where you have a discharge decision which is reasoned, and you have a new intervening fact coming post original decision, that can introduce a deficiency or irregularity in the original decision. But the only way of identifying that is if there is a reasoned decision. If there isn't a reasoned decision and there's no requirement to give a reasoned decision, then the new intervening fact cannot rubber stamp the original decision as being deficient or irregular.
Well, I think you better take us to those cases to make good the point you've just made. You needn't do so now unless you want to. I mean, you would, if you want to, by all means. I just don't want to take you out of your course.
My lord, yes. If I could take my lords to the
okay.
The case of Mohammed in Birmingham, page 253 in the authorities bundle. This is a decision of this court. Looking at what was then Regulation 8.2 now Regulation 7.2, and how that regulation was to be applied. If I can pick up the facts, page 258, paragraph 17. What happened was that Miss Mohammed told the council that she was refusing the offer that had been made because it was too small and she was frightened of heights and didn't want to live in a high-rise flat. On the same day, the officer notified Miss Mohammed that the council decided that it considered the property was suitable, reasonable to accept, giving detailed reasons, and that it considered that it had discharged its duty to her under Section 193. And that
where do we see that?
That's at page paragraph 17, my lord.
Okay, let me just read that. Yes, thank you.
My lord, that that was the original decision, namely the discharge decision following the refusal. And then turning to paragraph 27, page 260 of the bundle. Mr. Justice Proudman refers to and cites Lord Justice Lewison in NJ. I'm quoting from in NJ paragraph 70. Can I ask my lords to read that?
Yes, thank you. Yes, I mean, that's a useful
Indeed.
summary, but in fact, the jurisprudence about subsequent events goes back to the decision in Banks, doesn't it?
It does, which was also again, sorry, my lord.
Yes, but I was that's really in the sense I think you're about to tell me. We really need to look at, or at any rate be told about, if you say it's clear, what the position is in each of the cases where this subsequent change of events jurisdiction has been invoked. Are you saying Banks was likewise a discharge decision?
It was a change of a decision from priority need to not being from being homeless, not being homeless, and then on review to, because a notice to quit had been served, to becoming not in priority need. So there was a change in the decision.
So it wasn't a discharge decision, but it was an adverse decision and reasoned.
Indeed, reasoned. My lords have Banks in the bundle at tab 9, page 179.
Yes.
And my lords will see from the head note, the terms of the facts, that there was a change in the application. It was the second application. First application was that the decision was that Mr. Banks was homeless. So they refused it on the ground that although he was homeless, he didn't have a priority need. Shortly afterwards, my lords will see that he found accommodation, make a second application, and they found that he was not homeless, and then requested a review. And then before the review was concluded, there was a notice to quit. And then the reviewing officer concludes that yes, he's homeless, but varied the original decision and concluded no duty on the ground he didn't have priority needs. So again, it was an adverse decision followed by an adverse review decision with reasons, both reasoned. And my lord, well, if my lords could turn to page 195 of the bundle. It's the at the top of paragraph 71.
Sorry, which page were you on?
Sorry, my lord. Page 195 of the bundle. At the top of the page, it carries over 70, para 71.
Yes.
My Lords, it's the purpose of construction overriding need to ensure fairness. And one can see in banks the stark contrast between an original decision that you're not homeless, varied on review to yes, you are now homeless, but you're not in priority need, and the requirement, how Regulation 7.2 engages in but to ensure fairness to an applicant, where the intervening facts change the landscape.
What if it could be known with certainty that a particular fact or a particular document was not taken into account in the original decision, notwithstanding that it was not reasoned, and that later fact or document was plainly material? Would that then have to be ignored just because the original decision was not reasoned?
My Lord, it wouldn't engage Regulation 7.2, but if there's a new fact arises, a particular document that is then presented to the authority, then that under general principles of both material considerations and procedural fairness and the duty to conduct proper inquiries would engage to ensure that an authority could not ignore the particular document or indeed refuse to take it into account, because if by way of representation on review, the applicant presents a document which changes the nature of the argument, then the reviewing officer is going to have to deal with that, and would have to deal with that within the representations. Now, the question is as to whether or not he needs to go back to having received the representations is a general inquiry challenge, if I can encapsulate it as such.
Well, I see how you put it, but let's suppose you have an offer letter which doesn't merely state suitable.
Yes.
It rather, like this one, explains that the location's fine and so on and so forth. And then while the review is underway, the person in question is involved in a very serious car accident and becomes a paraplegic. So there plainly is some new event that wasn't taken into account at the stage of the offer letter. If, as we can see from banks, and you accept where there has been a reasoned decision, a subsequent event can reveal a deficiency. Well, why shouldn't that subsequent event reveal a deficiency in the offer letter? Because plainly the offer letter was made on a different basis.
My Lord, if the offer letter is reasoned, and then so one has in a sense the question then for the court is to decide whether or not a reasoned offer letter, when it's not required to be reasoned, opens the door for Regulation 7.2 to apply, and therefore require a minded to find notification to be sent regardless. In my submission, my Lord, that is going beyond the purpose of construction of the regulation, because it is imposing a requirement to send minded to find notification where neither the where the statutory scheme doesn't envisage, nor does in my submission, my principal submission, the regulations do not engage, because there's no requirement to give reasons, and the fact that there is a reason given doesn't then lead to the engagement of Regulation 7.2 and therefore requirement to comply with it. That's taking the purpose of my submission, purpose of construction, to the point at which it is to be, the Regulation 7.2 is to be interpreted as requiring all local housing authorities to send minded to find notifications.
But logically, I mean, suppose my Lord put you, if I was listening properly, the case where the offer letter was gratuitously reasoned. But suppose the pure case where it wasn't reasoned, it simply said it is suitable. And then the supervening paraplegia occurs, and it immediately becomes evident to everyone it's no longer suitable.
Yes.
You say 7.2 not engaged at all. The original letter wasn't the original decision wasn't in any way deficient. And you also say that what I might call the bank's line of authorities doesn't apply either. But why not?
Because, my lord, there is a requirement to provide a reasoned decision, which is the original decision.
Yes, but the problem here has not been that there's a deficiency in the reasons. The problem is that events have changed. We make it absolutely clear that a decision needs to be taken again on a different basis. And that's that, and therefore, why shouldn't you purposively interpret Regulation 7.2 and say, well, there's a supervening deficiency, if you like, not because there's a deficiency in the reasons, but because there was a deficiency in the expressed reasons, but because there was a deficiency in the substantive decision and the thinking that went into it, because they didn't know he'd become paraplegic. He hadn't, in fact, become paraplegic. So the same, you might say, sleight of hand, which was performed by Lord Justice Lawrence Collins, would be equally appropriate in that case as in the case where reasons were given, wouldn't it?
My lord, one can't forget that within that even with even if the Regulation 7.2 is found to not engage, where there is a supervening event, and as in this case, rendering the accommodation clearly unsuitable because of access arrangements, then the authority are going to have a duty, general duty, and to conduct proper inquiries to determine what duty, if any, is owed, and that will and take into account material considerations. The general principles apply, and they would have to take into account that event, and they would have to then make inquiries to deal with that event to make sure they're able to make a lawful decision, which may involve going back and making further inquiries as to the extent of the injury and the.
Well, that basis, Regulation 7.2 is a bit of an unnecessary provision anyway, because there's always a duty of fairness.
There's always duty of fairness to apply.
So
but
you would say, even apart from Regulation 7.2, whenever something comes up which wasn't considered first time round or wasn't apparently considered first time round,
what regulation? Sorry, my lord, I cut across.
Then there will be a duty of common law fairness for the reviewing officer to consider the situation as it is now, as drawn to his or her attention.
What Regulation 7.2 brings to the party, if I can use that phrase, is the requirement to serve a mind to define notification with a right to make further representations. Whereas if the general principles of fairness and inquiries and taking into account material considerations apply, there is no requirement for there to be a mind to define notification. That's what Regulation 7.2 imposes. It imposes a step before the authority can issue a decision on review. They've got to serve mind to define, together with the reasons why they're to so find, and then consider any response. And what that is an extra step that is required by the regulation, introduced by the Secretary of State, which is over and above the general principles.
I mean, it's plain as I understand it that the 2018 regulations, as you say, provide across the board for the person affected to make representations and the reviewer to take them into account.
Yes.
But where there is a deficiency, which can be a retrospective deficiency, the Secretary of State has thought it appropriate to introduce this extra step.
Yes, but that's it only engages when one looks at what is the original decision to determine if there's a. Apologies, I'm repeating myself here. If there's a deficiency or irregularity in the original decision, and if there is no deficiency or irregularity in the original decision, then it doesn't engage. and then the applicant then falls back on the general principles of fairness, duty to conduct proper inquiries and material considerations.
I mean, to go over really old ground, I mean, I can see that if you have a one-line statement in the offer letter, we think this is suitable, it may be hard to show a deficiency in that decision unless there has been some subsequent event. But if there has been a relevant subsequent event, why can't you say, well, that can't have been taken into account in the original decision?
It can be taken into account and must be taken into account if it's, for example, a change of medical circumstances rendering the property unsuitable due to access. It has to be taken into account. It doesn't engage Regulation 7.2, which is the duty to serve a minded to find notification. It doesn't require local authorities to take that additional step, which is extra resources and in terms of time and costing in dealing with applications. If the court were to conclude that in respect of an offer of suitability, or accommodation is determined to be suitable, that that Regulation 7.2 is engaged, i.e. there has to be a minded find notification, then one has to apply that across the board in respect of all offers of suitable accommodation. And in those circumstances, my submission, that takes it beyond what was the purpose of Regulation 7.2, given the statutory scheme. So the starting point is looking at the original decision. If there's no reasons, it can't be deficient. The safeguard of the minded to find notification doesn't have to be taken into account, but the authority clearly then have to take into account the representations that they have. And it's only where there's a discharge decision with reasons that one can then apply assess whether or not there's a deficiency or irregularity in the original decision. The second point, my lords, is that the original, it's for the reviewing officer to make the decision as to whether or not there is a deficiency or irregularity in the original decision. So so it's a matter, and that can be challenged on public law grounds, Wednesbury grounds. Now, in this case, I move on. If my lords are against me on my first submission, namely that Regulation 7.2 isn't engaged, the officer in the original decision does consider whether there's a deficiency or irregularity in the original decision, and we can see that at the end of the decision at page 74. And that must be seen in the light of the preceding assessment of the issues, and the conclusion that that number 61, sorry, apologies, the property was suitable for Mr. Querino because he was to be seen as a single person, and applying the council's policy. There were no exceptional circumstances that justified the grant of a property larger than one bed with more than one bedroom. So the officer addresses the question of Regulation 7.2 and concludes that it didn't contain a deficiency or irregularity. And when one looks at the original decision, and my lord's point in respect of, well, actually this goes beyond just a bare assertion, this is a suitable accommodation reasonable to accept, and goes on to explain why, in the offer, the council address the policy, the relevant policy, para 5.5.1 and 2, which the reviewing officer cites in his decision at page 61, and in the original letter, they're satisfied that as far as children, while he may want to have more than one bedroom, if the officer making the offer was satisfied that one bedroom was suitable for Mr. Querino because of the policy, because of the policy as applied. The fact was that the children were safe and had a home with the mother, and it followed under the policy, which my lords can see at page 61, that a child living at separate addresses will only be considered as having one main residence unless there are exceptional circumstances which mean that both parents should provide a home. So that's the policy, that there must be exceptional circumstances for a child to have effectively two homes, and that it's for an assessment to be carried out by the council. So in terms of deficiency, there is, in my submission, no deficiency or in the original decision. And the because the original decision maker has addressed the same issue which was submitted on review, and the only additional factor is the report, and whether the report adds anything to the considerations. The issue in respect of the report, my lords will have seen my note.
Before you come to that, just talking round it.
My lord.
So suppose that we weren't in the territory we are in, where you say Regulation 7.2 doesn't bite at all. Suppose we were in territory of discharge decision or whatever.
Yes.
And suppose that there had been available to the original decision maker a CAFCAS report, and that the review officer knew that that had not been taken into account. Suppose that one could see that the original decision maker had in mind the sorts of things said in the CAFCAS report, but nonetheless had forgotten entirely what the person making the CAFCAS report had said. Would Regulation 7.2 bite there?
If there was a specific aspect of the report that had, so for example, the report concluding that it is imperative that both parents provide a home for the child. So the report and the advice, the recommendation in this hypothetical situation, the recommendation was that both parents provide a home for the child. That would clearly be relevant for consideration of whether it's exceptional circumstances, and if the original decision maker hasn't considered that, and that can be demonstrated that he has failed to consider that, then clearly that is a deficiency.
Yeah.
But,
sorry, go on.
Sorry, my lord.
No, go on.
So if there is for the purposes of this this appeal and this report wasn't available to the original decision maker. What we know was that the representation of I want to have more than just one room because I need my children to stay with me was made and was then considered, and the policy applied and the decision made that this is not one of those exceptional circumstances where two homes would be provided for one child. And that was the conclusion of the original decision maker. The reviewing officer, when looking at the original decision, is able to see that that's been the process by which the officer has gone through to determine whether the accommodation is suitable. Yes, he has now got the CAFCAS report. Let's set aside the fact whether he should have had it or not. In my submission, he rightly concludes he cannot refer to it and discounts it immediately. And my submission, that is the right response. He cannot refer to it without permission, and the court had not at that point in time, and that's the relevant date, it's the date of inquiry, date of the review decision, that he could not refer to the report. But that didn't mean he couldn't deal with the question of whether 2 homes should be made available for 1 child, effectively. And he does deal with that. So is there a deficiency in the original decision? And my submission, no, because the facts are the same, namely that this is an applicant who wants a 2 to 3 bedroom property so that he could accommodate his children for the time that they are going to stay with him and while when not staying with their mother. So that's the policy 5.5.1 being applied, and it was open to both the original decision maker and the reviewing officer to reach the conclusion that under the policy there wouldn't the accommodation provided is suitable because there's not exceptional circumstances and you only need 1 room.
And can I ask you one more question before you develop anything further you need to say on how the review officer simply wasn't entitled to take into account the CAFCAS report?
My lord, yes.
In terms of the point you were just making by reference to page 74 and what the review officer says, she says, I've concluded that the original decision didn't contain a deficiency as it was made on the information available to the officer at the point of decision.
Yes.
Now, we've rehearsed whether 7.2 applies at all, but supposing that 7.2 is capable of applying, was the review officer right to look no further than the information available at the point of decision? Because might it be said, well, banks and other cases show that it can be relevant to consider things after the date of decision?
My lord, in terms of does it by reason of the parking aside whether you can, well, I can't park the CAFCAS report because at the very outset of the decision, the officer parks the CAFCAS report and says I can't refer to it. So he decides that at the beginning of his
Sorry, I'm not picking you up on
my lord.
gender for the sake of it. It's a bit confusing. The original decision maker is he, but the reviewing officer is she.
I apologise. You're quite right, my lord.
And so we don't get muddled as to who we're talking about any time.
My lord, apologise. The reviewing officer at page 61 makes it very clear before he starts consideration of the relevant the representations and the facts that he was disregarding any submissions you have made specific to the report, and neither will I put any information specific to the report in my considerations. So she. I got the wrong way around. I apologise. She rightly in my submission makes that point right at the very outset in terms of what information I can and cannot take into account. So for the purposes of identifying the deficiency, is there a deficiency or irregularity, homing in on the CAFCAS report, she was right to say that I can't take that into account because at that point the court had not given permission for it to be produced or relied upon. And we can see from the response from Ms. Jackson.
So just coming back before you go to that, so would this be fair that there could be a case where the reviewer had been wrong to look only at the information available at the point of decision because even on your case, in a different sort of case, you would have to have regard to things that had happened subsequently.
My lord,
But here, all that had happened subsequently was the arrival of the CAFCAS report, which you say could not be taken into account.
yes. And we can, I accept that Lord Justice Lewison in NJ does a point 4 in the quote that we can see taken in Muhammad, refers to the reviewing officer should treat regulation 7.2 engaged whenever she can, an important aspect. That inadequacy, part number 4, may arise because of a subsequent change in fact. So there must be consideration of subsequent events. But for the purposes of the in this appeal, the CAFCAS report couldn't, and was rightly, couldn't be relied upon, couldn't be produced, and couldn't, and the officer was right when she said that she will neither put forward any information specific to the report in her considerations or deal with the report. And she was, the reason she was right to do so was because we can see in the supplemental bundle at page 227, she confirmed, 4th paragraph, I can confirm that the court hearing on the 17th of August went ahead, that there was leave for the father to share the court order, not the Section 7 report, with yourselves. So he had obviously asked for permission to produce the report, and the court had refused to do so, but had given permission to rely on the court order.
Well, I think you're reading too much into it. It's leave for the father to share the court order with yourselves. Whether or not the Section 7 report is merely Ms. Jackson's gloss.
I accept that. We don't have the order.
No, it's rather surprising we don't have the order. I can see why you wouldn't have it, but I'm surprised that the father hasn't produced the court reports to us. But
the order has never been produced, and one in respect of the 17th of August.
Yeah.
So we don't know what the order was.
Well, we do. We've got sufficient evidence of it here. The key point is that your point is there would have to be an order saying that the report could be shown to the council.
Yes.
There is nobody has produced any such order, so that's probably enough by itself. But actually, we've got Ms. Jackson, who would know, saying that there wasn't such an order made on the 17th. So that's good enough for your purposes.
Yes. And her being the author of the report, one would assume that she was present at court.
Well, I dare say.
Whether we know it, we don't know. My lord, but in the second point is that as far as the report is concerned, it contains just recommendations.
Do you mean as to disclosure, or generally?
Just generally.
Yes, I see.
And in respect of disclosure, it was a disclosure to the local authority, recommendation that there should be disclosure to the local authority. We know that looking at page 227, the only disclosure that was permitted was the order. So I go back to the assessment of deficiency or irregularity. Was it open to the officer to conclude that there was no deficiency or irregularity in the original decision by reference to the fact that the CAFCAS report wasn't to be considered in that assessment? And her conclusion was, well, the officer in the offer has addressed the issue and applied the policy, which is what I've done in my decision. And there's no deficiency or irregularity identified. So looking at the situation of banks where there was a clear stark change in circumstance that led to a different decision, albeit the same conclusion, namely no duty was owed, but on a different basis, one can say, well, actually, there's is clear evidence of a deficiency or irregularity given rise to because of a subsequent event. In this case, there is no such deficiency or irregularity identified. So therefore it follows that, and that is a decision which is open to the officer to reach. So it's not a question of, well, the court would reach a different view, but is it one that was open to the officer to reach on the Wednesbury basis? And the answer is my submission, yes. It follows therefore that Regulation 7.2 wasn't engaged and there was no requirement to send a minded to find notification. Unless I can assist any further in respect of ground 1, I'll move on to ground 2, which is the question of
Can I just ask, not sure really how it affects the exact issues in this case, but it might affect implications for other cases. Although the review officer says she's not going to take into account the CAFCAS report as such, I can't remember what's the exact phrase she uses, but the substances as submissions specific to the CAFCAS report. It's not clear to me that the material which she in fact expressly considers what in my bundle is 64 to 65, no, sorry, 82 to 83, under the heading reasonable expectation of residence of the children, really sticks to what she said she wasn't going to do. There's a lot of material there which either must have come from the CAFCAS report, or if it doesn't, was nevertheless private information about the hearing, which she shouldn't have been told.
My lord, there's a fuzzy line between, on one hand, making representations which an applicant can make, namely, I need an extra bedroom because my children need to come and stay, and I need to be able to maintain my relationship. They should have two homes, and then, which is a submission that can be made, and indeed the policy 5.5.1 envisages that no doubt applicants for a Part 6 accommodation would.
Yes, but when she says things like, maybe your children wish to spend more time as their father, supported by the professionals.
Yes.
That must have come from the CAFCAS report, or at any rate, when it came to the CAFCAS report, it must refer to the proceedings. That's true, the professionals are engaged only in the context of the proceedings, aren't they?
I'm not, my lord.
This may not be a fair question for you. I'm just thinking about the wider implications. We'll have to hear from Mr. Van Heegem, but I obviously see the strength of the case that she absolutely shouldn't have referred to anything in the CAFCAS report. But I wonder whether actually the inhibition was rather wider than that. She shouldn't have been told anything that had happened in the proceedings, apart from a court order, which is there hasn't been any final order.
My lord, I agree that there should have been no reference to, or indeed communication of, the proceedings, because that's what the family,
Section 12(1)(a),
Section 12 family
yes.
Procedure rules, etc., require, and there are strict rules. The difficulty in, as I say, that there's a fuzzy line in that it is still outside the scope of that protection of those proceedings. It is open to.
Of course, I do see that, but in the real world, one suspects that some at least of the evidence which a parent in the father's position here wants to put forward will in fact derive from the proceedings. Well, I'm not going to explore this any further with you, but I mean, you and I'm sure Mr. Van Heegen practice a great deal in this field, though neither of you, as far as I know, are family practitioners. No. But this sort of overlap must happen quite often, I would have thought.
Not as often as you, my lord, thinks it happens.
No, that's very useful to know.
But in terms of procedure, in terms of family proceedings, the starting point is there is a clear, defined boundary of containing information that shouldn't be disclosed.
Well, perhaps I can just ask you this, not as evidence, of course it's not evidence, but just to get a feel for how these things are dealt with. On those not very common arrangements or circumstances where it does arise, unless you want to say it never arises, are you familiar with courts making explicit orders that a Kafkas report can be referred to?
My lord, I haven't. No,
you haven't seen that happen.
I haven't seen. What I do see is as homeless applications being made, where there's a split between a couple, and the applicant is seeking accommodation. That is common, where they're looking for larger accommodation than
in order to accommodate substantial overnight access.
And that is, and it is open to authorities. So actually, as is the policy, we will not provide accommodation for two homes for a child.
I see all that. I'm asking a slightly more specific question about what sort of to and fro happens in such situations between the counsel and the review officer, who's really the key player in all this, and the court. I mean, you will sometimes have cases, depending on the timing, where a judgment from the court may already have been given or may be imminent, saying finally what the family judge thinks should happen about shared accommodation, about shared access, overnight access. And they will, I'm sure, be very careful, at any rate since Holmes Morehouse, about attempting to dictate to the housing authority. But do you nevertheless get cases where these questions are addressed by family court judges, or are they? No.
The reason being is because I suspect the reason is that the family court contain a strict boundary of information that isn't to be disclosed until a court decides whether it should be disclosed.
Yes, but what about once that it has been decided?
And once it's been decided, then a decision would then have to be made by the local housing authority based on the facts that are, and I've not come across a review decision where the authority reject the family court judge's conclusion as to, for example, there should be two homes provided for one child, and say we're not going to provide accommodation because I suspect where a family court have concluded that in the interest of the child there needs to be two homes, that would probably be an exceptional circumstance.
I see. Well, I wasn't really asking you to speculate about all that. I was really just trying to pick up on your experience of what happens in practice in this sort of situation. And the answer I think I'm getting from you is that one way and another, this sort of situation doesn't arise very often.
Doesn't rise often.
No. That's probably all I need to take from you. And
the production of the report without permission creates a cloud of confusion in that, as my lord has identified within the decision letter, having said we're not taking it into account, there's a reference to professionals. Now, one would say, is that taken from subconsciously from having read the report and then feeding it into the decision, or is it because there's representations, and indeed there were full representations, which refers to professionals, so which would be legitimate submission to make even outside the Kafkas report.
Okay. Sorry. Yes. No, I was about to say I didn't need to hear any more.
I should know this because I looked at section 12 yesterday, but I can't remember exactly how far it goes. Is the father allowed to say, look, I am applying to the family court for extra access, which would involve my children staying overnight?
Section 12 covers the publication of any information relating to proceedings, Children Act proceedings.
Yeah, well, I think the authorities, in answer to my Lord's question, make pretty clear that the mere existence of those proceedings is not a matter covered by Section 12.
Yeah, oh, yeah, sorry, yes.
It's the information about what goes on in court.
Yes.
It was actually dealt with in the other Griffiths and Tickle.
Yeah.
Proceedings.
Quite right. So you can't. There's no secrecy as to the existence of the proceedings.
And
No,
is
there
there
is
any?
a question as to whether a particular application
Yes.
is captured?
I mean, the father can presumably say, I would like my children to stay overnight. Is he allowed to say, I would like my children to stay overnight and I'm applying to the family court for that? Is he allowed to say, I have applied to the family court for that?
My response to that would be that he can't. Because that is going into the nature of the proceedings and applications and considerations by the court. What is not the purposes of these proceedings, what is not open to the applicant is to disclose the report and then say, well, there's a deficiency or irregularity because you failed to take it into account. And it's a supervening event that requires, identifies a deficiency. In any event, the report itself doesn't, in my submission, take anything further forward. It may be that it has weight because it's written, it is a Kafka's report written by Ms. Jackson. But it's only, at the end of the day, it's the matter for the court to decide, and it's what the court determines, having made fact-finding decisions, as to, or indeed, in this case, by agreement between the parties, what child arrangements were to be made.
I had thought, but I'm not finding where I'd thought it from, that if the family court makes a final order, it is not an attempt to publish that.
That would be right.
I haven't actually found where it says that, but
I would suspect that must.
12.1a is very broadly
It is
worded,
broadly
but
worded.
as my lord says, it's been explained helpfully, particularly in Griffiths and Tickle
Yes.
twice.
Indeed. So my lord, ultimately the conclusion of the family proceedings must be a public document that can be produced. So for the purposes of Regulation 7.2, the Kafka's report shouldn't have been produced and cannot feature in the assessment of deficiency irregularity. My lord, can I move to the second issue, and that is the question of whether or not the local authority is required to ascertain whether the licence to occupy the temporary accommodation provided by them can be terminated so that the Part 6 offer can be taken up. My lords, can I take your lordships to the statutory scheme, section 193, page 73, sorry, page 34. This is the section that deals with the discharge of the main housing duty. The main housing duty we can see in subsection 2. And that is to provide, to secure accommodation is available for occupation. And then the subsequent sections identify the ways in which that duty comes to an end, how that is finally discharged. In subsection 5, subsection 6, which we which don't apply in this instance, and then in
You say 6 doesn't apply. Why doesn't 6C apply?
yes, 6C would apply because it's an acceptance of an offer, part 6. But there's the acceptance is of you still have the right to request a review of the suitability of the acceptance.
Absolutely, I follow that, and indeed,
Oh, right.
Section 206 says that anything that the local authority does in discharge of its functions has to involve securing suitable accommodation. You can still review suitability,
Yes,
but subject to that,
it discharges
the duty will have come to an end under
Yes, it
6C.
Indeed. And subsection 7, the authority shall cease to be subject to the duty if the applicant, having informed of the possible consequences of refusal and his right to request a review of suitability, refuses a final Part 6 offer. So, in this instance, subsection 7 deals with refusal of a Part 6 offer, and 7A, an offer of accommodation under Part 6 is a final offer for the purpose of if it is made in writing and states that it's a final offer. Then if we turn over the page to page 36, subsection 7F, the authority shall not make a final offer of accommodation under Part 6 unless there is
I'm not sure that these words matter, but I wouldn't wish them to be overlooked because it doesn't actually stop there. It says for the purposes of subsection 7.
Yes, indeed.
But that might make a difference if you're actually relying on subsection 6.
Yes. Yes. Because subsection 7 deals with refusal, subsection 6 deals with acceptance. But then if we go over the page, my lord, just in terms of understanding the scheme, how it works, subsection 7F, the authority shall not make a final offer of accommodation under Part 6 for the purposes of subsection 7 unless they are satisfied that the accommodation is suitable for the applicant and that subsection 8 does not apply to the applicant. So they cannot make a final offer of accommodation under Part 6 unless they're satisfied that the accommodation is suitable and subsection 8 doesn't apply. And subsection 8 applies if the applicant is under contractual obligation or other obligation in respect of the existing accommodation and not able to bring those obligations to an end before being required to take up the offer, i.e. the offer of Part 6. So, in the facts in this case, the relevant facts are that Mr. Querino was offered and provided temporary accommodation at 116A under a licence from the council's own temporary housing stock, and at page 175 in the supplementary bundle, my lords can see that it is an excluded licence between the council and Mr. Querino.
What licence?
An excluded licence.
So, and what does an excluded licence mean?
An excluded licence means they have no rights to protection under the Protection from Eviction Act and can be summarily evicted effectively. So they have no right to remain, and that licence can be terminated without notice.
I'm not saying you're wrong, but I just don't know. Perhaps you're about to come to this, in which case stop me and I'll wait. We haven't seen the full terms of the licence, but what I would assume a licence would be would nevertheless contain, whatever the statute might say, some sort of short notice period, and there's presumably also an obligation to pay. Trying to think of the word one that uses when one doesn't call it rent, but I mean to pay for the light, pay for the occupation.
Yes.
So that as a matter of pure contract,
Yes.
Just suppose it said 28 days, which it probably doesn't, but just suppose it said 28 days and you left without any notice, you would have to pay, in principle, damages for breach of contract equivalent to 28 days rent, subject to the obligation to mitigate.
Yes.
So, sorry, 28 days license fee. That's a reasonable inference, isn't it, as to what, not having the actual terms of the license, of what kind of license it was.
We do know it's 7 days, don't we? It says
Do we?
7
I'm
days.
sorry. Oh, well,
I'm just going to take your lordship. If we go
oh, well,
to,
there you are. I'm sorry. It's my fault for getting ahead of myself.
my lords can turn to page 175. My lord is right in the respect of that by contract there is a requirement to
Which page am I looking at?
175 of the supplementary envelope.
Oh, yes,
That
sorry.
deals with what happens after an adverse decision in respect of a homelessness application.
Yes,
There hasn't been an adverse decision.
That's true.
my lord, yes.
I mean, I'd always taken it that the council could, and as a matter of practice would, waive any rights that it did have.
I'm just about to come to that, my lord.
Yes.
Because in this instance, we have council accommodation, temporary stock being occupied under an excluded licence, which is bare contractual rights, and that is it, no statutory protection at all. And then the offer of social housing from the council's own housing stock, and so Mr. Querino was moving from temporary accommodation provided by the council to a secure tenancy provided by the council. And there was the offer was made and was accepted, and he moved in. There is no evidence that there was any obligation or any contractual or other obligation which prevented Mr. Querino from moving out of the temporary accommodation and into the
Well, hang on.
social housing.
Well, that's what I was just trying to unpick. I'd have thought there probably was a contractual obligation,
Then,
but as my lord says, which seems to me to be the real point, the council is never going to insist on it. The council is going to waive it. The starting point, I thought that there probably is a contractual obligation. We don't know what it is. Real word, it's largely theoretical, because even if he left the accommodation in order to just leave and go somewhere else, or does he come into money, they're never going to come after him for the remaining 28 days. I'm sure they move someone in the next day. So it's all a nonsense, really. But I don't think the right way into this is to say he won't be in breach of any contractual obligation if he moves out at short notice. It's that they won't enforce it.
what's required is that the applicant is not under contractual or other obligation in respect to the temporary accommodation and is not able to bring those obligations to an end.
Well, that's the point. Yes.
That's the point, my lord, is that he's got to be in a position where he cannot bring, in this instance, the license. Let's say it's 7 days. Let's say it is 7 days or whatever
Whatever it is.
That he is not able to bring those obligations to an end before he's required to take up the offer.
Yes.
So in a private context, which I'll take, my lords, to the decision of Norton of this court, that was dealing with a private rented sector offer So an arrangement between the tenant and
Yeah.
the applicant in the private sector, where there would be a date you've got to start by, and whether or not he was able to comply with that, and whether or not he was able to bring to an end his temporary arrangement to be able to take up the offer of the tenancy. In this case, on the facts, we know from the review decision, there's no dispute on the facts, that Mr. Querino accepted the offer on page 57 of the decision letter. And the tenancy commenced on the 12th of August 2022 and is currently in occupation of the property. So what has happened is that he was offered the accommodation and he moved in. And the tenancy started on the 12th. There was no sign, there's no evidence, and indeed no representation made by Mr. Querino that he was not able to bring his obligations for 116A to an end before he was required to start the tenancy on the 12th.
But I mean,
There's another-
but but it goes a bit further than that, doesn't it? Doesn't it just say the necessary inference of the council making an offer that he move effectively from out of one of their properties into another of their properties on a different basis, but still, is that they will not that they will waive any obligations for any period after he vacates, even if it's short notice. Isn't that's how it seems to me? But I don't know.
Well, I was going to offer a different
Okay.
or supplementary interpretation. Looking at the bits that we do have of this
Yes.
license agreement, it starts off by explaining the reasons for granting a temporary license to occupy, explaining that it's in order to give effect to the interim duty to accommodate pending a decision, and goes on to say in the final sentence of the first paragraph that the license is granted solely and exclusively under that duty, for no other reason. All of which implies that it is that the period of the license is up to and including the time of the decision,
Yes.
but not beyond it.
No.
That seems to be supported by the second paragraph, which says that it's a temporary license which will subsist pending the council's decision as to the duty. And then the 7-day notice looks like an extension to cater for the situation in which the decision is we don't have a duty. So you've got to find some accommodation
Yourself.
for yourself.
My lord,
That's a much more intellectually respectable way of putting what I put in much broader.
But not wanting to pour cold water on my lords.
I put it to you only so you can knock it down. Really.
My lord, the authority made the decision as to what duty was owed and concluded that they owed the duty. So he remained in occupation of that temporary accommodation pending further discharge or final
They
discharge.
made the decision earlier.
Yeah.
Yes.
Yeah,
So
that doesn't work.
unfortunately, my lord, it does, because there was an earlier decision of duty owed. So what normally happens is where temporary accommodation is provided pending determination of what duty, if any, is owed, and the decision is that we owe a duty, the applicant then remains in that accommodation until they can find suitable accommodation for further discharge or ultimately final discharge of the duty that is owed under 1932.
There's a license at will.
It is.
Can I add in one more ingredient? I mean, actually, we're back to 7F, and 7F asks whether the council is satisfied that subsection 8 doesn't apply.
Yeah.
If the council knows that, as it's the landlord of the temporary accommodation and the new accommodation,
Yes.
that it isn't going to present any difficulty, well, it can be satisfied that subsection 8 won't apply.
Indeed.
Okay.
The inference, my lord, referred to being an inference that one can read within the decision letter, namely that the offer was made, it was accepted, the tenancy began on the 12th of.
And we are ultimately concerned with whether the council was satisfied as to this fact, rather than whether it was objectively so. I mean, I quite follow it probably was objectively so, but why shouldn't the council have been satisfied as to the fact when it was the landlord of both
Indeed, and
properties.
that's the point that I made below. That we're one and the same, and it's a matter of if we're satisfied. There's no, not only are we not satisfied, not only are we satisfied
Yeah.
that there is no difficulty in terms of obligations and not being able to commence the tenancy, but also for the purposes for the applicant, for Mr. Querino, he didn't present any issue as to, well, I've got to pay for the 116A and I've got to start the tenancy on, and therefore I'm paying twice for two properties. So it was in those circumstances the offer could be made of the property.
And can I just float another thing? In your skeleton, you say something about, well, what would the relief be anyway in circumstances where the offer has been accepted?
My lord.
And I just wonder whether that finds expression in 7F, because it says that the local authority is to make a final offer of accommodation for the purposes of subsection 7. It doesn't say for the purposes of subsection 6.
My lord, yes.
So what I'm floating is the idea that if the offer is actually accepted, you're not in this territory because the duty will have come to an end under subsection 6C, and you don't have to worry about subsection 7 at all.
I can say, my lord, yes, because of the reference to the word part.
For the purposes of subsection 7.
7.
And I'm not quite sure why those words are there unless they are indeed intended to take you back to subsection 7 and not subsection 6.
Indeed, and subsection 7 deals with the refusal specifically, because it is, in a sense, one can see why Parliament does expressly refer to subsection 7, because when the circumstances where there has been a refusal, then it leaves the applicant with no duty and having to find accommodation on their own. So, in a sense, the requirements to discharge and not provide accommodation for an applicant who was owed the main housing duty, the standards and the requirements are going to be more onerous. So that in terms of fairness, the applicant actually knew all the requirements and the rights, but also was able to actually move in and decided not to. My lord, the third ground deals with the Kafkas report and the finding of the judge in respect of apologies, my lord, I haven't taken my lords to Norton. I don't propose to take your lordships to that. My lord, the ground 3 deals with whether the council erred in not considering the report. My lord, I don't want to repeat my submissions on that. The report is a report that should not have been disclosed and can't be considered and couldn't be considered. The court made the order on the 29th of March allowing the applicant to rely upon the report. That's the first time officially the matter could be reported, or it could be referred to and relied upon. And in my submission, it cannot at that point determine the lawfulness of the review decision, because it's to be the lawfulness of the review decision to be determined on the facts as at the date of the review, and therefore the matter shouldn't. The decision is not unlawful by reason of the failure to take into account or indeed to make inquiries as to whether or not that report can be officially produced before the decision was made. My lords, just in conclusion, the review decision is a full letter, reasoned, addressing the relevant matters that need to be addressed and identified as was permitted to be identified in the representations on review. It is a balanced decision which was open to the authority to conclude in the light of its policies. The decision maker clearly identifies the relevant issues, considers them carefully in terms of residence of the children and what would be in their interests. She considers the carefully the housing circumstances of the area and the shortage within the area, and then the particular circumstances of the applicant, and reaches their conclusion in relation to the property that's in terms of its requirements and the location and affordability of the property, and then concludes at page 73 her findings, which are, in my submission, matters that clearly open to the council to reach, and is not one applying the Holmes Moorhouse principle, is not one that the court should interfere with. Unless I can assist.
Can I just pursue a bit? I think there's some idea in what's said against you. Well, the review officer should have done more to find out. I mean, I could have been more in terms of getting permission to use the CAFCAS report, or more in terms of waiting for the hearing, which I think was due to take place at the end of December, was it?
I think it was, yes.
Don't know what happened at the end of December, but seemingly there was a hearing to happen at the end of December. So what about the idea, well, the review officer should have said, I'm not making a decision for now, let's find out more.
Well, two things. One, it's not for the council to seek permission from the court to rely upon the CAFCAS report. It's for the applicant to present the representations and to obtain the necessary permissions and court orders that are required to be able to rely on it. Having received that confidential report, the right approach was to say it can't be taken into account. We've been advised there's no permission to produce the report, and therefore it will be excluded from consideration. And thirdly, if circumstances changed after the date of the review, then by reference to court orders and circumstances had changed even more, then it would be open to the applicant to represent as an applicant to say, well, circumstances have changed. He could either make a fresh homeless application or ask the council, given the decision of the court in December after the review decision, to withdraw the review decision and to carry out a fresh review. No requirement for the authority to do that, but they could represent and make a fresh homeless application saying that the circumstances have completely changed and require a fresh determination as to the duty owed. That wasn't done.
Is there procedure in the statute for reconsidering a review?
No, but there is homeless applicant can make a fresh application.
Oh, well, that I've understood. Yes, I thought you were presenting two alternatives. I hadn't heard of reconsidering a review because of changed circumstances.
Moore's quite right. There is no procedural requirement.
Are you telling us this sometimes happens pragmatically?
Pragmatically, sometimes. They can, so for example, using the paraplegic scenario, review decision saying it's clearly suitable, car accident no longer suitable, then either they withdraw the decision or they have to, a fresh application would then be submitted to say, well, this accommodation isn't suitable.
No, I get that alternative. I just hadn't heard of the withdrawing and doing it again. Okay, thank you.
Can I just try one other thing?
My lord.
How far was the review officer under time pressure? I mean, we know there was due to be a hearing at the end of December. She makes her decision in November. Was she up against a time limit, or could she simply have waited till January?
Review decisions have to be made within 56 days of the request for the review. The request for the review was the 8th of September. So that would take you to 8th of October, November. This is 24th of November. I don't know whether there was an agreement to extend the time so that the review could be completed by the 24th of November. In the absence of any agreement, then the applicant would be entitled to appeal against the original decision. That's their protection. In this instance, I don't know whether there was a particular time pressure. What there wasn't was there wasn't a request by the applicant to say, well, look, we've got a hearing in December, and we're can you wait for that decision?
Certainly wouldn't be unlawful to wait if asked,
No.
by agreement.
Yes.
Yeah.
The council weren't aware.
Council were aware of the forthcoming hearing.
They were, apologies, they were. My lord, they were. Page 227, 29th and 30th of December, they were aware. But there was no request by, and indeed, even if there was a request for deferral of the review decision, there's no guarantee that the family court would have agreed to disclose the report or whatever.
No. What one would, if
So
we said earlier, if what we're told is right, if there was an order,
yes,
and if that is in the public domain, we would at least know what the order was.
yes, and it's not in the public domain. My lord, unless I can assist your lordships any further.
We might just rise for 2 minutes. Thank you.
All right, please.
Can I please remind the courtroom that the live stream is still running? Thank you.
It states blah blah blah, and so then you at 7F
rise if able.
Yes, Mr. Manning.
I intend to take the grounds in that order. Before I do, during the course of our submissions and in relation to ground one, we wish to rely on the case of McKeesey and Birmingham City Council. We have copies. May we hand them up to the bench?
Of course, yes.
This is in relation to, I'll come on to it, but it's in relation to how Regulation 7.2 applies to suitability reviews, because the issue has already come up before the Court of Appeal.
Thank you very much.
Before I turn to my submissions, I just want to make two quick points just to deal with issues that arose right at the end of my own friend's submissions. In relation to looking at reviews again, this is dealt with in the Act itself in section 202. So if my lords turn to the authorities bundle,
So I've got the Act separately, so I hate those internet printouts. But
right,
if you tell me what section.
yeah,
I'll
I'm going
find
to
it.
look at section 202, subsection 2. It's on page 67 for anyone following in the authorities bundle.
202.
Subsection 2.
Yes, thank you.
So there's no right to request a review of a decision reached on an earlier review.
Yeah.
And while we're looking in the authorities bundle, the review procedure regulations.
Are you still on that point?
No, no, it's a related point about timing of the review. So,
Oh, I see. Yes. Well, it's very unlikely we need to mention this, but is it within your own experience, as it was with Mr. Colville's, that pragmatically councils sometimes revisit, let's use a slang term, a recently concluded review rather than require the applicant to reapply in the case of a change of circumstances?
that's not my common experience. What happens is the applicant would lodge an appeal with the county court, at which point the local authority might see the light and decide they're going to revisit their review.
As it were, on the back of, yes, I see. Well, anyway, that's fine. It doesn't say they can't, it just
No.
says there's no obligation.
Exactly.
Yeah. Okay, thank you. That's all I need to know.
And then the other point I wanted to make in relation to Moloney Friends' submissions at the end was the timing of reviews. So page 108 of the authorities bundle is the review procedure regulations.
Mhm.
And the timing of reviews is dealt with in regulation 9 on page 114. And if my lords look at the end of 9.1, as my learned friend correctly said, there's a time period. It's normally 8 weeks, but that period can be extended so long as the parties agree in writing.
Yes. Thank you.
So to start with ground one, regulation 7.2, what I want to do here is just look at some of the cases and bits that we haven't seen from the cases, then go to the Act, then look at the suitability order and the code just to set the legal framework, and then look at what happened here by looking at the offer letter and then the review decision. So if I can start, if I may, with McKeesey, which is the case that I passed up. My learned friend appears to be making the sort of macro point that regulation 7.2 doesn't bite on suitability reviews. And in my submission, there's no authority for that. And McKeesey goes against that. So if one looks at the facts of 2 of the cases that were heard with McKeesey, So I'm looking at page 1547 of the judgment that I've handed up.
Yes.
One can see from letters C to D that McKeesey was a case where the reviewing officer upheld an original decision that a final offer was suitable and therefore they'd been discharged. I accept there'd also been a discharge decision, but it was an offer decision, it was a suitability decision.
But that doesn't, on the face of it, go against Mr. Colville because
There's a discharge.
there's a discharge.
Yeah. Turning over the page to Nagy. This was a case again where one can see from just above letter E that it was a decision of that it was deemed suitable and therefore they didn't consider him to be homeless. And then this is a decision of Lord Justice Etherton as he was, and if the court look at paragraph 68, I'd invite the court just to read from just above letter E to the end of the paragraph, so the sentence that starts by contrast.
Yes.
So in my submission, this does show that the Court of Appeal have decided that, in this case it was about 8-2, but it's now 7-2, does apply to cases including suitability decisions.
I'm not saying you're wrong, but that is obviously, it says what it says, but is that ratio? I don't know enough about what the issues in the case were.
Yeah, I'm not going to say it's ratio. It seems to be more a general discussion about the scope of Regulation 8.2 by way of.
So that's how it reads, thank you.
It has to apply in order to get on to what the regulation
I mean, it's ratio in the sense that, as I've already shown to the court, 2 of these appeals concern suitability decisions. And so in order to get within the scope of Regulation 7.2, the court had to decide that suitability decisions came within the scope of the regulations.
But Mr. Colville says, well, look, where the local authority says that its duty has come to an end, then there will be a reasoned decision, and yes, Regulation 7.2 applies. The point at issue may be suitability, but it will be in the context of a reasoned decision that the duty has come to an end.
No, I accept that, but that doesn't exclude that where the decision is solely one as to suitability, Regulation 7.2 is excluded. I want to now look at some of the other cases in the bundle on Regulation 7.2. If I could try and take them in chronological order, I want to go back to banks. I'm looking at page 193 of the authorities. I want to start at page 65 of banks.
Page or paragraph?
Paragraph 65. Again, this is a case about Regulation 8.2 that predecessors 7.2. The paragraph 65 is making the point that the procedural safeguards are of the highest importance. Significant departure could afford a ground of appeal. And then at paragraph 68, there's extensive quotation from Hall and Wandsworth. And this is useful because on page 194, it sets out what a deficiency is. And I'm here looking at paragraphs 29 and 30 of Hall. So it doesn't have a particular legal connotation, it just means something lacking. It must be of sufficient importance.
So sorry, where are you reading from?
Page 194, paragraph, it's 29 of Hall.
Yes, I see. Thank you. Yep.
And then paragraph 30, this is where we get the point about important aspect of the case not addressed.
Yep.
And then my learned friend took the court to paragraph 71. I think it's important to look at paragraph 72 because that's more relevant to this case. So it's making the point that even if the original decision can't be faulted, it can come to have a deficiency. Now, in this case, if the review hadn't been done on time, then the applicant, now the respondent, would have the right to appeal against the original decision, so the suitability decision taken in the offer letter. And at that point, he would have difficulty if Mr. Colville's right and that decision was lawful. But what happened in this case is that there was a review process. And so even if Mr. Colville was right and that original suitability decision was lawful, that doesn't mean that it's not deficient for the purposes of Regulation 7.2. And that's what's being said here in Banks.
One of the ironies of this case, one that probably doesn't matter to anything, is that the material that is said to give rise to the deficiency was produced by your side.
Yes.
And you made representations on it.
Yes.
So if one's sort of looking at it purposively, does the reviewer need to tell you about this material and give you a chance to make representations on it? Well, you have. You told the reviewer about it.
So I'm going to come on to this point now when we look at Mahmood, but what would ordinarily happen is one would get a nicely reasoned original decision, so you know where the authority are going, you know what decisions they're going to make. In a case such as the present, where we say Regulation 7.2 is engaged, you don't know, you're in the dark. You sent in the CAFCAS report, you said what you said about the CAFCAS report, but you don't know what the authority is going to say about that. And that's why you need a minded to letter. That's why we needed a minded to letter in this case. Because in fact, the authority came back and said, we're not going to look at your CAFCAS report at all. And by the time they did that, that was the review decision. It was too late for the respondent to do anything about it. It was too late for him to go off and get the permission that the authority said he needed. So all that he said about the CAFCAS report was on the face of the review decision entirely ignored. And that's the unfairness. That's the thing that's sufficiently important in this case, is the rejection of his submissions on that basis, and a basis which he doesn't know about, because of course it's not dealt with in the original offer letter.
I'm taking you entirely out of it, of course, but the ironies sort of get greater. You say the unfairness. You say the deficiency arises from material that couldn't be taken into account because you weren't told it couldn't be taken into account. But if it can't be taken into account, how can it create a deficiency?
I will come on to that, but I think it's important to draw a distinction between the content of the CAFCAS report, which it appears can't be taken into account, and the existence and fact of the CAFCAS report, which supports exactly what the respondent's saying on the review. And it's important not to elide the two, because the new fact in this case was the existence of the CAFCAS report, regardless of whether or not one could look at its content, and the fact that it supported what the respondent was saying during the course of the review.
But isn't that its content? You can't just say it exists and make a meaningful point. The moment you start saying it supports my case, you're talking about its conflict.
Well, I think I don't want to say anything about family law and how it applies, but I think the applicant is entitled to say, I'm saying this, and I have a document produced by a professional which says this, which supports what I'm saying, because that's a very much more weighty argument.
But you can't say that without. You say you don't want to say anything about the family law. I'm afraid you've got to. It's an issue in the case.
It is an issue in the case.
But if you're perfectly entitled to say, now that I've seen the material and been forced to look at it a bit more overnight, I agree that that the report shouldn't have been produced. If that is your position, fine. But if it's not your position, you're going to have to argue it.
Well, our position is we don't make that concession because it's not 100% clear to us exactly what orders were made and so on. But it seems that it probably shouldn't have been produced. But that does.
Orders were made without your client knowing about them.
Well, yeah, I mean, he would know about them, but they're not before this court.
Yes, but it's a bit difficult for you to stand there and say you don't know what they are when your client's behind you.
Yeah.
And he does.
Well, I can ask him in the lunch and adjournment.
Well, he knows whether he made an application for permission to use the report. And you're not saying he did.
Well, I'm saying I haven't had the opportunity to ask him about.
Before the court suggests that no such order was made.
Exactly, I accept that.
It's
But
not contradictory.
no, but I'm not going to concede the point that it shouldn't have been served on the authority. But I'm not going to dispute that.
Right. Won't make a formal concession. But won't dispute. Okay, thank you.
So just finishing on these cases, I want to look at Mohamud next because it sums up a lot of the jurisprudence, starting at paragraph 27, which that is page 260.
Hang on one second.
Yeah.
I just want to finish my notes. Right? Yeah, sorry, Mahmood, yeah. Mahmood.
So the court's already looked at this. I'm going to take it fairly quickly. The first principle taken from NJ is that regulation now 7.2 imposes two mandatory duties. So the reviewing officer's got to consider where there's a deficiency.
So you're going to the same passage that where Mrs. Justice Proudman cites from NJ, is that right?
Exactly.
Yeah, okay.
So the first principle is the dual mandatory duty. Second principle is that the performance of that duty can be challenged on public law grounds. And pausing there, and I think my learned friend concedes this, the review decision must give reasons. So if one's going to say there is no deficiency, one must give reasons, and those must be lawful reasons. Point 3 is a guide to when regulation 7.2 is engaged, which we've seen has been taken from Hall. So whenever an important aspect of the case was either not addressed or not addressed adequately, and our submission is the existence of the Kafkas report. And then the fourth point is about the inadequacy arising because of a subsequent change in the facts. And then paragraph 28, which my friend didn't take the court to, is dealing with the subsequent change in facts. And one can see from the second bit of paragraph 71 is that the new facts will expose a deficiency in the original decision if, in the light of those new facts, that issue was either not addressed or not addressed adequately. Which we say is this case because the Kafkas report wasn't addressed. And we draw the distinction between the content of it and the existence of it and what the authority had to say about it. Because had the authority told us they weren't going to take it into account because it was confidential, then that would have given the respondent the opportunity to then go and get the permission which he lacked, and that would have then enabled him to be able to rely on the content. And that's the procedural unfairness in this case.
I'm just wondering about that. So that's the procedural unfairness, is that not that he didn't know it was confidential, because it says so on its face, but that he wasn't told that the council was going to take that seriously. That seems to be the point.
Well, again, I'm not going to concede that he or his representatives didn't realise it was confidential. They seem to be labouring under the belief that they thought that it could be sent to the authority because one of the recommendations in the report was that the authority considered it, and the whole purpose of the report was that it was compiled against the background that he was making a homelessness application and he didn't have space for his children. So, in my submission, and given that they're not family practitioners, they're housing practitioners, they may not have known that it was confidential. The authority go away and they ask Miss Jackson and they get Miss Jackson's opinion. And in my submission, they should have then communicated Miss Jackson's opinion to the respondent and his representatives. Because at that point, if they were ignorant, and it seems that they probably were, they would have been alerted to the fact that they needed to go and get the permission. And given that there was a hearing coming up, that wouldn't have been a particularly difficult thing to do. And then they could have agreed an extension for the review. He could have made his application.
Well, at the hearing which was coming up, in fact, it would have become old history anyway, because an order would have been made. And the CAFCAS report, even if admissible, is only a recommendation.
Yes.
Insofar as it goes before the housing officer, it's of doubt, it's of some value, but it's of doubtful value because the judge might take a completely different view about it.
And the authority could have said that in the review decision, but all that inquiry and the ability to take into account the CAFCAS report and the role of the CAFCAS report was all jettisoned by the authority because they took the view that because it was confidential, they weren't going to look at it.
They're just trying to break it down, which I probably can't do. The deficiency, you say, is revealed by the existence of the report.
Yes.
So as soon as the review officer knows that there is a CAFCAS report, without having any knowledge of its contents at all, the review officer concludes that there is a deficiency in the original decision.
Yeah, because as my lord says, they don't know about it until it's sent to them, I think, under cover of the letter of the 11th of October. At that point, they know about it, and they know, if they read the representations, that it allies with what the respondent's arguing on the review, so it supports his
Well, on this hypothesis, they're not entitled to know that. So what I'm sort of trying to tease out is, suppose those instructing you had simply written to the council and said, you should be aware that a CAFCAS report has been written, and very properly said absolutely nothing about the contents. Would that have revealed a deficiency in the original decision?
Yeah, certainly, because an inquiry had not been made, and at the time of the suitability decision, the authority didn't know about it, didn't take it into account, couldn't have known about it. It was an issue that wasn't addressed and couldn't have properly been addressed because they didn't know about it.
So, I mean, plainly the CAFCAS report couldn't have been addressed, but mere knowledge that there is now a CAFCAS report means that there is a deficiency. I mean, suppose there have been successive CAFCAS reports, and at the time the first decision is made, the council knows that there is a CAFCAS report, and then it's subsequently told, without any further amplification, there's been a supplemental CAFCAS report. Does that reveal a deficiency in the original decision?
Yeah. Can I answer that when we look at Holmes Morehouse, which we'll look at in a moment, as to what the authority needs to know? But prima facie, our position is that the respondent's representations on review hinge on the CAFCAS report because there are children proceedings going on at the same time against the backdrop of the homelessness application, which are considering his accommodation, what would be suitable for him, whether his children ought to come and live with him. It's the most important piece of the jigsaw in relation to the review.
Well, they could have said as submissions, without reference to CAFCAS report at all, Duncan Lewis could have said, to some extent they did, but they kept blurring it. It's important for the children that they keep up a relationship with him. It's important for him and his mental health and all the rest of it, and therefore he needs a second room, second bedroom. They could have said all of that. So it doesn't all hinge on the Kafka's report. You say it is reinforced by the fact that professionals are saying so too.
Yes.
Yes, well, that I get, but you do, of course, get into the difficulty then that you have to refer to the fact that what the professionals are saying, which you can't do without getting permission of the court.
No, but that triggered what the authority should have been triggered to do is say, we're not taking this into account before the conclusion of the review, so that he's able to remedy exactly that problem, because he's stuck between a rock and a hard place. He wants to advance what's being said in the Kafka's report in support of what he says on the review, but he doesn't realise he can't do that until the conclusion of the review, when all is revealed and it's said, oh, well, actually, we're not going to look at the Kafka's report at all. So he's handicapped in his conduct of the review because he just doesn't know the way in which his prized piece of evidence is going to be treated on the review.
But just coming back to the question, so suppose it is the case that the review officer couldn't be told anything about the contents of the report, but could be told that there was a report. You say, well, the mere fact that you now know that there is a report reveals a deficiency in the original decision because inevitably it comes after the original decision. But we're concerned here, aren't we, with challenging the review officer's decision on public law grounds?
Yes. Yeah.
So you have to say that the review officer had no choice but to conclude that the mere fact of knowledge of a Kafka's report made the original decision deficient.
I'm going to get onto that point as well. But I say that the authority don't even get off the starting blocks, because when they come to consider whether or not there's a deficiency, they don't consider any of this at all. And they wrongly say, oh, well, the original suitability decision was fine because it was based on the material we had at the time, which is entirely the wrong approach for Regulation 7.2, which requires you to look back with the benefit of hindsight on the original decision.
That's only if something has changed, and nothing has changed other than a report which no one can refer to.
Well, the authority has to make that decision. They either say there's a report but nothing's changed for X, Y, and Z reasons, because they have to give reasons because it's a review. But they don't do that in this case. Their whole approach to Regulation 7.2 is entirely flawed, because they just take a rather simplistic attitude of, well, the decision was okay on the material, the decision was lawful on the basis of the material
This is
we had at the
the
time.
point that you put, as it were, first in your service and argument
Yes.
on this. We don't really get to any of the detail because they simply didn't address their minds to this at all. And that in itself is a
It's difficult, isn't it? Because there are 2 points really. Aren't the local authority making 2 points? One is the decision was unobjectionable on the basis of the material that was available at the time. And secondly, the only piece of extra material that we've got is inadmissible, putting it in legal terms. Either of those would do. So if they're wrong about the first one, but right about the second one, the review decision is unimpeachable, isn't it?
Well, when we come to look at the way in which they approach deficiency, it'd be my submission that they don't take the second of those. They stop simply at the original decision was lawful on the basis of the material available at that time. They don't go on. Had they gone on and said, oh, but now there's the Kafka's report, but that can't be taken into account, then that would be a much more difficult decision to challenge. I'm conscious of the time.
no. That's if it seems to you like a good place to break. It seems so to me as well. Very well. 2 o'clock.
All rise, please.